And we all know what those are. Basically, self-defense primarily is the ultimate personal use of arms that's lawful. And of course, hunting is also a common use of arms, perhaps sport to some extent. But basically, if you have an arm that people would want to use for lawful purpose commonly, not some bizarre exotic arm, but something normal, then that's going to be protected. And that means that while it can be regulated, it cannot be abolished completely and it cannot be banned. And handguns clearly fall into that category. Handguns are the preferred self-defense tool of Americans today. About 40% of all firearms manufactured today are handguns. Handguns, when guns are used in self-defense, about 80% of the time the gun used is a handgun. So while certainly handguns can be misused, handguns are very commonly used for lawful purposes consistent with the individual right to arms. So you cannot ban handguns. The other question, of course, is the functional firearms ban, which the Supreme Court also handled, I think, quite well, and stated that, yes, you do have the right to arms which are functional. What did our case not present? Our case did not really ask the court to give us the so-called standard of review. For those of you who are not lawyers, when the court announces or declares or finds that there's individual right, oftentimes the government's regulation of that right will be analyzed according to some test which is fashioned. And historically, that test has been outcome determinative. If we had a really tough test for the right, then the government would almost always lose. If we had sort of an easy, relaxed, deferential test, the government would almost always prevail. In recent years, the court has moved away from having a test be outcome determinative. In many cases, the Supreme Court has told us that strict scrutiny, for example, the toughest test, is no longer fatal in fact, as one popular myth, as the Supreme Court now calls it, would hold. That is, a right can be subject to strict scrutiny, and yet laws regulating that right would survive. So the tests are no longer outcome determinative. The court's moved away from them. Our case didn't really require the court to announce a right, because if you have a right to arms, clearly you can't have a law that says no arms. And it's going to be for some future case to determine what the test might be. Happily, however, the court did give us a few clues. The majority opinion does tell us that these laws would fail any of the tests which are commonly applied to enumerated rights, and the hint there is, of course, a very high level of scrutiny, because enumerated rights historically have always been given a very, very high level of scrutiny. So I think we're going to be okay on the strict scrutiny angle. Incorporation, of course, as I mentioned, not an issue in the case, but the court did mention in some length, the 14th Amendment history. The 14th Amendment, of course, when it was ratified, was widely intended by the 39th Congress, which enacted the 14th Amendment, to secure the rights of freedmen to have arms, because that was the problem at the time. What we found out after the Civil War was that we had two main defects in our Constitution. The first one, obviously, was slavery. That was remedied by the 13th Amendment. The second one was the concept that we only had a Bill of Rights to guard us against deprivations of the federal government, that there was a theory that your state government wouldn't violate your rights. Why would they do that? You'd vote them out, of course. Well, that didn't work out so well after the Civil War, and of course, even if we didn't have a Civil War, I think it's something that I would have hoped the Americans would have recognized at some point. But the 14th Amendment basically was intended to say, listen, states, you can't violate the rights of U.S. citizens. You have to respect constitutional rights as well. The Supreme Court has not always been faithful to the 14th Amendment. They adopted a policy of what's called selective incorporation, where every once in a while they would look at a right and see if it's important enough, if it's fundamental enough, if it's really something that we should apply to the states, and then on a case-by-case basis they would adopt it and have the right apply to the states. No decision on that yet on the Second Amendment in this case, but I think there are some definite clues in there, and I'm looking forward to, of course, seeing that question resolved. I think that's going to be resolved almost immediately. And so there we have it. I think it's probably time for questions.